The trial for the three former Minneapolis police officers charged in the death of George Floyd has been delayed at least until March 2022. It was originally set for August. So why did the judge want the trial pushed back? Lou Raguse joins us from the newsroom to explain.
Well, Lauren, a couple reasons. First, now that all the officers face federal charges as well, the defense attorneys all agreed that the federal case should go first. And Judge Peter Cahill also made it clear that because of the publicity from the Chauvin case, including what's to come in late June when he's sentenced, they need space before that second trial starts.
March 7th, 2022 is the new date when former MPD officers J. Alexander King, Thomas Lane, and Tu Tao are scheduled to stand trial. They're charged with aiding and abetting second-degree murder and second-degree manslaughter in the death of George Floyd, and if found guilty, face the same potential penalties as Derek Chauvin. But their new federal charges carry heftier penalties. If found guilty of deprivation of rights, also known as criminal civil rights violations, they could face up to life in prison. The defense attorneys and Judge Peter Cahill said that case should be handled first. In court, the prosecutors said they don't agree with the trial delay. Also in the hearing, Tao's defense attorney Robert Pauley wants to find the source of the leak that led to this New York Times article in February, just a month before Chauvin's trial began, detailing plea negotiations for May 2020. It says Chauvin believed that the case against him was so devastating that he agreed to plead guilty and was willing to go to prison for more than 10 years. Pauley called the leak the most outrageous conduct he's seen in his career. Judge Cahill chastised prosecutors for not following his request to submit affidavits swearing they were not the source of the leak. Only Assistant Attorney General Matthew Frank has done so. So now Cahill says he'll schedule an evidentiary hearing in August in which prosecutors could potentially be subpoenaed to testify, as could New York Times reporter Tim Arango, although Cahill said, "I'm a little skittish about putting a journalist on the stand and jailing him if he doesn't reveal his source."
And a New York Times spokesperson told me that Minnesota law protects reporters from exactly these kinds of subpoenas. The New York Times will vigorously defend against any effort to target our reporters and their sources. And also in the hearing, Earl Gray, attorney for Thomas Lane, argued that prosecutors should have to turn over 30 years of use of force complaints from MPD to see if any officer ever intervened in the way the state argues that Lane, King, and Tao should have with Chauvin. That issue is also still pending. Lauren.
All right, a lot happening. Lou, thank you.